From January 2011, Australia has a single national consumer protection law, the Australian Consumer Law. As part of the Competition and Consumer Law, the Australian Consumer Law replaces the previous consumer provisions of the Commonwealth Trade Practices Act and State and Territory Fair Trading Acts. The Australian Consumer Law is all about safe products, fair contracts and sound sales practices for all Australians wherever they live and work.
While these laws mean new protections and clearer rights for customers, there are also benefits for business. For a start, it means one set of rules for business instead of over 17 different state and territory laws. So for businesses that operate across various states, this is a real plus.
The Australian Consumer Law, or ACL, is also intended to be clearer, putting in black and white and plain English trader obligations and consumer rights to increase certainty for all.
As well as applying to all purchases of goods and services for household use, the ACL also applies to goods and services for any purpose, including business use, for items costing up to $40,000. This will give small business in particular clearer rights when dealing with other businesses for common purchases. Some of the key elements covered in the ACL include protections against unfair contract terms, consumer product safety, guarantees and refund rights, sales practices including door-to-door sales, telemarketing and lay-bys. There are significant penalties for breaches of the new law. These penalties are expected to provide a much greater incentive for compliance.
We want to help you be aware of your obligations under the Australian Consumer Law and where to go to find out more or keep up to date.